Hello, welcome again to Business Immigration Online. This short presentation is about the Immigrant Petition. We discussed this is part of every green card application for a foreign national based on employment has to be preceded or filed at the same time with an immigrant petition. Now, what is an immigrant petition and what it does? The immigrant petition is the instrument that places the foreign national in line for a immigrant visa number. So once the adjudication is complete, the person should know where they are in line for the green card or for the immigrant visa number. Now, EB1, EB2, and EB3 uses similar formats and types of evidence are required in order to establish eligibility. Of course, there is some variation based on the specificities of each particular subcategory because each one of them has some other element that need to be proven. In general, the immigrant petition has to be filed by the sponsor, which is usually a U.S. employer. And in some situations that we saw in EB11 and in national interest waiver, it could be filed by the foreign national, what we call self-petition. What has to be established in a petition? First of all, there has to be evidence of full-time permanent job offer when this is required, and it's required in all cases in EB1, 2, and 3 unless there is a self-petition. So other than national interest waiver and EB11, as we spoke, there has to be a full-time permanent job offer. Evidence that the foreign national qualifies for the offered positions. It's great if the foreign national is able to come to the US, but if the specification of the position that the employer seeks to certify are such that the foreign national does not meet, that petition cannot be approved, obviously. Wherever a labor certification is required, it has to be provided. It has to be provided generally in the original. And there has to be evidence that the employer petitioner can pay the preferred wage. This is not required, of course, in the cases that we discussed where the beneficiary can self-petition. But ability to pay the preferred wage, it's an indication that once the company completes the process and once the person becomes a green card holder, the company will be able to pay them. There are prescribed ways of how to prove ability to pay, but in general, that has to be shown at the immigrant petition level to show that this is bona fide and that it's going to happen because the company can afford it. Some points. The petitioner, the employer or beneficiary in self-petition cases, must designate or select the basis for the petition. And this is how USCIS is going to look at it. So if the person or the employer chooses EB2, they will look at it against the qualification for EB2. If the person does not qualify for EB2, even though they may qualify for EB3, for example, the petition might be denied because the person does not qualify for the classification that was thought. So that is this is important. And most petition for EB1, EB2, and EB3, other than national interest waiver again, and EB13 for multinational managers and executive, can be filed generally in premium processing. Premium processing allow for a much faster adjudication by USCIS of the I-140. That premium processing does not extend to the adjustment of status application if that is filed as well. So essentially, when the visa number are available, then at the time of filing, then the foreign national and their family members may file for a green card adjustment of status if they qualify at the same time when the immigrant petition is filed. So in many cases in EB1, in EB2, and many times in EB3 as well, oftentimes when the I-140 is filed, it is accompanied by a pack of green card application of the beneficiary and their dependents, meaning spouse and unmarried children under 21 in most cases. What an approval of the immigrant petition entails. First of all, most importantly, it establishes a priority date, which is usually the date the petition received by USCIS, unless a labor certification is involved, and then the priority date is the date the Department of Labor accepted the labor certification for processing. This is important. There can be a year difference between the two, sometimes even more. If the case with the Department of Labor takes a very long time, still the person will get the priority date at the end of the day when the process began with the Department of Labor. This is very important. Um, it also established the classification with these two determination. First of all, the priority date. Secondly, the establishment of the classification. A person can find themselves on the visa bulletin and can know where to look for their priority date, wait times, and to check when they become current. Okay, so the I-140 is the document that obviously that at the end of the day establish the priority date and the classification. Another important feature, once a priority date is established, the foreign national may use that priority date for any future EB1, EB2, or EB3 petition with other employer or with self-petition. And this is very important, especially for those chargeable to countries where there is a very long retrogression of visa number, mainly in the area of employment, India and China, mainland born. In those two classification. In these two groups, um, people sometimes have very long wait times, and often they change employment and require to do another I-140 by a new employer and another labor certification. If they can use a priority date from 5 years ago, that can make their wait time much, much shorter this time around. So that's a very important thing. Remember, two other things that approval of I-140 provide is one, ability to extend the H-1B beyond the 6 years by 3-year increment until visa number becomes available. And a relatively recent one that once an I-140 is approved, a spouse of H-1B might be able to get a work authorization, and again, that's a big relief for those families that have sometimes have to wait years without the spouse being able to work.